to pay his son a sum rupees 1 lakh if the son passed CA exam in the first attempt. The son passed the exam in the first attempt, but father failed to pay the amount as promised. Son files a suit for recovery of amount. State along with reason whether son can recover the amount under Indian Contract Act. Tell me, class. Apply your concept and then give me the answer. That is so simple. Okay, so as we know, according to Indian Contract Act, whenever offer is made, offer is to be accepted is equal to promise. In promise, when consideration is there, is equal to agreement. Agreement plus law enforceability is equal to contract. So this is the formula of contract. Okay. So the agreement can be of various types: social agreement, religious agreement, okay, social, religious, legal. We have to focus only on the legal agreement because legal agreement is enforceable in the law, in the court of law. And this example that I have given you, the father son, this is the domestic, or we can say the this one social. So that's why this cannot be enforceable. Okay. So in this case, we can say the son cannot recover the amount. Okay. There is a very famous case, Balfour versus Balfour. That's the husband-wife case, and the social agreement is there. So in husband-wife case, because sometimes the questions can also become in from the Balfour versus Balfour. So husband and wife just went for the holiday. The wife admitted in the hospital. The husband promised that I will give you monthly, but after 3 months, the husband stopped paying. The wife filed the case. So the court held that this case cannot come in the contract because this is a social thing. So many examples of this can become in the court of law. So that's why Section 10, let's talk about the backbone of Indian Contract Act. So as per the provision, the parties must intend their agreement to result in legal relation. Agreement of social or domestic nature do not contemplate legal relationship and such are not contract. It cannot be enforced by law. Important. Okay, so that's why the son cannot recover the amount 1 lakh from father because of the reason explained above. That is important. Okay, so this is the exact reason of this question. Now the next one. A offered to sell his house to B for rupees 10 lakh. B accepted the offer but stated that he would pay 9.5 instead. Letter A refused to sell the house. Can B enforce the contract? Whether there is a valid acceptance, because there are three questions that is involved. Three questions. Can we enforce the contract? Whether there is a valid acceptance of the offer? Can be legally compelled to A to sell the house? So class, in this case, first of all, see, in any contract, there must be one offerer and the one is offeree. Offerer, offeree. So offerer, the person who offer, right? In this case, A is offerer and B is offeree. So guys, if offerer is selling the house, so the condition should be done by the A person. But in this case, the B is saying, I will take this with a 9.5 lakh. So this cannot be done. So can we enforce the contract? The answer is no. Can there is a valid acceptance of the offer? No. Be compelled to sell? The answer is no. Please say this. Cool. Okay. So this is the right answer because offerer always have to put some conditions. This is the right answer. Okay. Next. Mr. Ram Lal Birla was a big businessman of the city Pune, having two sons and one married daughter. So Ram Lal, S1, S2, and daughter. He decided to gift one house to his daughter. For this purpose, he called his lawyer at his house and made a written document for such gift. The lawyer advised him to get the transfer document properly registered. When they both were going to registration of the document, they met with accident and both were died. Later on, his daughter found the document and claimed the house on the basis of the document. Now, tell me, class, this is very good question. Whether she can get the house as a gift under Indian contract. I'm giving you 2 minutes of time. Tell me, class. A very important question. So class, the answer is very simple here. See, first of all, I think you people have know this quotation that section 25 of the Indian contract say that an agreement without consideration is void. An agreement without consideration is void. Okay. But there are certain exception, and in exception it say that an agreement without consideration is what? Valid. This is the exception, right? So same thing apply here. So in exception, if any gift is given with a natural love and affection to the other person, it must be written and registered. That is a law. But in this case, it is only a written one that is not registered. So that's why she cannot take house as a gift under Indian contract. See what is written here. General rule is that an agreement made without consideration is void. We know that. Section 25. But there are few exceptions to the rule. One of the exception is agreement made on the account of natural love and affection. Section 25 provides that an agreement made without consideration is valid if it is expressed in written and registered under the law for the time in force for the registration of document and is made on the account of natural love and affection between the parties standing near relation to each other. So in this case, Mr. Ram decided to gift his house to his daughter. He made an agreement in written, not registered. So that's why the daughter cannot claim. Okay. So transfer of house made by Mr. Lal Birla on account of natural love and affection between the parties standing in relation is written, not registered. Hence, the transfer not enforceable. His daughter cannot get the house as a gift. That is very good question. Very good question. Cool. So this is called a case studies question. So in case studies question, if you know the concept, you can easily do that questions. At least 15 to 20 questions. Sometimes 25 question also comes from the case study question. Okay, now Shambhu Dayal started self-service system in a shop. Srimati Prakash entered the shop, took a basket, and after taking articles of her choice in the basket, reached the cashier for payment. The cashier refuses to accept the price. Can Shambhu Dayal be compelled to sell the said article to Srimati Prakash? So class, in this case, As we know, the difference between invitation to offer, okay, and offer. In the formula of contract, offer come in the first place. Before offer, there is invitation to offer. So suppose when there is a sale in the market, that is called invitation to offer. So in this case, as you can see, can Jambu Dayal be compelled to sell? The answer is no. Okay. So this is the right. He cannot compel to sell because that is only the invitation to offer, and invitation to offer, you cannot compel the shopkeeper. Cool? Next. Mr. X invited Mr. Y at his business partner for X sister's marriage. Y accepted the invitation in this ground. X booked a table in a costly hotel where the marriage take place. Due to some reason, Y could not attend the function. So what type of contract is this? A valid contract? Justify your answer. That is really a good question. A, agree to sell land to B. So there is a contract between A and B, okay, for rupees. This is the land for rupees 40,000. Okay, this is for 40,000. Okay, B pays to A rupees 4,000 as a deposit at the time of contract. It means B have deposit 4,000 as we can say the security. Okay, the amount to be fortified to A if B does not complete the sale within the specified period. It means B have deposit 4,000 as a security, okay? And it is written in the contract that if B is not able to pay, so in that case, the money will be automatically belongs to A. That is written. Okay, now B fails to complete the sale within the specified period, nor is ready and willing to complete the sale within the reasonable time after the expiry of that period. Can A rescind the contract and at the same time retain the deposit? That is important. Tell me. That is good question. Tell me, class. A agree to sell. This is important question. Yes, class. That is important. A agree to sell land to B for rupees 40,000. B pay to A for this. So in this case, class, can A rescind the contract? The answer is absolutely yes. Yes, A rescind the contract. Why? Because as it is already given that the B have not paid the price within the time. So that's why. That is the only reason. Okay. So in this section 54 of Indian contract, if promises are conditional and dependent, okay, the performance of the promise by one party depends upon prior promise performance of the promise by other party. Exactly. So in this case, B have to perform the promise. If B is not able to perform the promise, then A cannot do. Okay. So in such promises, if the party who is bound to perform his promise first fail to perform it, then he cannot claim performance from the other party. Moreover, the defaulting party becomes liable to pay the compensation to the other party for the loss suffered by other on the account of non-performing of the contract. So here A can rescind the contract at the same time he can retain the deposit. That's it. Because that actual that is written in the fact. That's why. Okay. So this is the right answer. Cool. So no need to learn the section. Okay. In this case studies question, basically 4 MCQs always be there. So you have to tick mark on the correct one. Okay, you have tick mark on the correct one. Cool. That's it. Next. Mr. Ramaswamy of Chennai placed an order with Mr. Shah of Ahmedabad for supply of urad dal on 10/11/2006 at a contracted price of rupees 40 per kg. The order was the supply of 10 tons within the month time before 9/12/2000. This. So Ramaswamy and Mr. Shah have a contract. Okay. The contract have to be completed within 9/12/2006. Okay. The contract is of your urad dal. Okay. And urad dal exactly. On that, when the contract was there, so it was 40 rupees per kg, the price of the dal. Okay. So on 4/12/2006, it means you can say before the contract, Mr. Shah wrote a letter to Mr. Ramaswamy stating that the price of urad dal was skyrocketing to rupees 50 rupees per kg. He would not be able to supply as per original contract. The price of urad dal rose up to 53 on 9/12/2006, advised Mr. Ramaswamy, citing the legal position. Tell me, class. So, class, as we know that the Mr. Shah have not performed the contract, okay, but the contract have been already breached. So there are breach of contract in this case. Breach of contract can be of two types. There will be actual breach of contract and there will be actual and we can say uh, anticipatory. So what is anticipatory? Anticipatory means the person have not performed the contract. Before contract, if there is a breach of contract, this is called anticipatory breach of contract. So in this case, there is a anticipatory breach of contract. Exactly. Okay. So it's occurred when the promiser refuses altogether to perform his promise and signify his willingness, okay, even before the time for performance has arrived. In such a situation, the promisee can claim compensation by the way of loss or damage caused to him by refusal of the promiser. For this, promisee need not wait till the time stipulated in the contract for fulfillment of the promise by the promiser. So this is simply the answer. Okay. So if the answer can be, if we just put the situation, so the answer can be of various type. Okay. The first is Mr. Ramaswamy can repudiate, we can say, end the contract on 4/12, can claim damages rupees 10 per kg. He could wait till 9/12/2006 and claim 1,30,000. This one. If the government in the interim, that is a mid one, between 4/10 and 9/12 imposes a ban on the movement, the contracts become void. Exactly. Done, class? 10 class. Okay, that's cool. Next one. Yeah, the next question is that is again important. PQR, a hospital in Delhi, recruits Dr. A on contract basis for the period of 3 months. The hospital management promises to pay Dr. A a lump sum amount 1 lakh if A tests positive for novel coronavirus during the contract period of 3 months. Identify the type of contract and highlight the rule of enforcement, and also what will happen if A does not connect with COVID-19. Tell me, class.